Hi, my name's Isaac Shutt. I'm an estate planning and probate attorney. I'm licensed to practice law both in Texas and in Wyoming. And in this video, we'll talk about one of my favorite things in the whole world, and that is the living trust. Now, first of all, let's get our terminology straight. A living trust is sometimes called a revocable trust or a revocable living trust. And regardless of the terminology, it all means the same thing. And so in this video, I'll call that a living trust. Now, a living trust is actually not a document. That's a common misconception. People think that a trust is a document, but it's not. It's a legal relationship, kind of like a company, but it's governed by a document. So if you're going to create a trust, what you really mean is that you're going to go talk to an estate planning attorney to draw up the trust agreement. Okay, so what a trust is this legal fiction that's governed by this document that's prepared by an attorney. So it's kind of like having a company that you're setting up, and what that attorney is doing for you is almost like setting up the bylaws for your company. It's the rules for your company. So that's what it is. Now, let's talk about some of the typical roles inside of a trust. Okay, you've got the settlor, grantor, or trustor. That all means the same thing. That is the person that sets up the trust. So in this example, that's you. You're going to the attorney to set up your trust document. You're the settlor, you're the grantor, you're the trustor. You are in charge because you set it up. You're also typically going to be named as the trustee. Now, the trustee is the person who manages whatever assets have been put into that trust. So you may not put hardly anything into your trust when you first establish your trust agreement, or you may put your home into the trust when you establish it. But since you're the trustee, you're the person who gets to decide what will happen to those assets. So since you're the trustee, you're in charge of whatever happens. To be really specific, a lot of our clients, we've got a married couple that comes in, they set up the trust agreement together, and then we recommend that they transfer their home where they reside into the trust. Well, a common question we get is, okay, Isaac, if we put our house into the trust, does that mean I can no longer sell it and move into a different house? And the answer is absolutely not. Since you're the trustee, you get to control what happens to that asset of the trust, in this case, the home. So you could do whatever you want with your home because you're the trustee. Now, the third and final role in a typical trust is the beneficiary. So the beneficiary is who the trustee is working for. The beneficiary is the recipient of the good benefits from that trust arrangement. So again, just to recap, the three main roles in the trust relationship are the settlor, grantor, trustor. That's the person who established the trust. Then you have the trustee. The trustee is the manager of the assets for the beneficiary. That's the third role. So the trust agreement, when you set up a living trust, is setting up the rules for those three parties. It says what the settlor, trustor, grantor is allowed to do. It says what the trustee is allowed to do for the benefit of the beneficiary. And this is where trusts and living trusts in particular really, really shine. So I'll give you kind of a typical scenario. Let's say we have a typical married couple that come in to my office, Bob and Jane. And let's say Bob and Jane have a couple of kids. And let's say they want to avoid probate. Well, a living trust does a really good job of avoiding a probate, which is the process that a will would go through when you pass away. So if you create this trust agreement with your attorney as the settlor of the trust, and then you transfer in your home and maybe your personal accounts, maybe even a vehicle. So now instead of having those assets in your name, they're now in the name of your living trust. When you pass away, technically, you didn't own those assets, but your trust did. And so you were the trustee up until the moment of your passing. So that means you were the controller of the assets. But as soon as you passed away, a successor trustee that you specified in your trust agreement takes over as the trustee. Now, that successor trustee will now work for the new beneficiaries that you've passed away. And those beneficiaries in this scenario would be your children. Now, because the trust agreement lays out all of those rules for what would happen if you pass away, there's no need for a will probate when you pass away because you didn't have anything in your name. It was already in the trust. And all that happened when you passed away is the new trustee took over for the benefit of those new beneficiaries. And so it avoided probate altogether. That's it. That's how a trust works. That's why they're so cool, because they avoid probate and they take things out of your name and keeping things out of the public record and totally automate everything of what would happen if you become incapacitated or if you pass away just by virtue of that trust document prepared by your attorney. So I hope you found this video helpful. Again, my name's Isaac Shutt. I'm an estate planning attorney. I'm licensed to practice law both in Texas and in Wyoming.